Hi, my name is Nalini Mahadevan, and we are from Mahadevan Law Office LLC. With me is Mark Moore, who works with me on our immigration applications. Today, we are going to talk a little bit about the current immigration climate, especially for businesses and employees. Our law firm is located in Clayton, Missouri. Our phone number is 314-932-7111. Let me introduce Mark. Mark has been with me for 2 years, and we collaborate on all our immigration applications. So if you call our office, you'll either get me or you'll talk to Mark or our other paralegal, Jamie Stafos, who also manages the office. Today we're going to talk about businesses, as I said, and items that affect business employers, businesses, and employees. Let's talk about the very first thing everybody calls me about, H-1Bs. So, Mark, what have you seen about the H-1B wage levels now?
We've seen a lot of additional scrutiny, particularly with wage levels, ensuring that wage levels are
Minimum.
above the minimum. It seems like there's been additional scrutiny, particularly on H-1Bs, and it's resulting in additional RFEs, requests for evidence, and it seems like instead of passing immigration reform, they're trying to
make it more difficult.
Right, advance the agenda through enforcement, and this is one area where we're seeing
Yes.
a lot of additional work.
So the H-1B is under a lot of pressure. Wage levels are being at level 1. The challenge has been that the job duties that are assigned to the employee are far higher than the wage level that is being paid to the employee. That's number one. The other issue we are seeing is a lot of challenge as before on the education and qualifications. An additional challenge is now on LCAs. Today, so if the LCA does not give the correct work address, or your employee is working at a third-party address, then if the employee is changed before the H-1B is approved, we are now seeing, and this has been brought to our attention, not from our office though, denials for an H-1B. This is a very hot button issue, even for exempt employees who are paid more than $60,000. Please be prepared to see more pressure on that. Even if there are no new regulations, there will be more upward pressure on wages for H-1B categories.
And there are strategies, I think, for addressing it or preempting it, and when you file your application to try and make sure that everything is prepared correctly and try and avoid those RFEs. And I think we do a pretty good job here of
trying to do that. Yes,
right.
Filing it what I call defensively. Yes. So the other issue is for those people who have already filed the let's go to now green cards. So employees who've already filed for their green cards, the I-140 has been approved, the 485 because the priority date is current has been filed. And then we are now seeing that all the employment-based I-140s and with 485s having been filed, those are all going to interview. Maybe not every application may be interviewed, but we are hearing that a large majority of these will be interviewed. So the next thing I would like to talk about is if your I-485 is being delayed, a lot of people are hearing the answer that there are background checks being performed. Please keep calling. Also, EADs in this context are being delayed, both for H-4, for F visas, for other L2 visas, all those for whom EADs have to be applied for, all those are taking much longer, because today I spoke to an officer at the call center, and they tell us that they are getting new officers in, and the new officers require a lot of training, are not yet ready to process applications on their own. So expect delays on your employment authorization documents. One caveat, please don't file too early. If you file too early, your adjudication is likely to be delayed. That's the other thing I was told today. So what are some other best practices for businesses to follow? I mean, we are urging employers to file their permanent labor certification for their H-1B employees and the L visa employees as soon as they can.
Yeah, and just making sure that all the documentation is collected and in place. And,
yes, especially prior. If you're saying they've been employed somewhere before, collect those documents first. Make sure all your ducks are in a row before you go forward.
And I think there's so much to just to be aware of and cognizant of. It's really good to have an advocate
Present.
Right, fighting for you and making sure that all the documentation is exactly where it needs to be.
So one of the things we've noticed is that when we file perms, that people with U.S. degrees seem to have a easier time. Not that we are against foreign degrees. A lot of us have. I personally also have foreign degrees. So it's not. I have no brief against foreign degrees, but a U.S. degree definitely does help. U.S. experience also helps to push the perm through with a minimum. Let's say audit chances are slightly lower. My last thing for employers is prepare the I-140 very carefully, document it well so that you're able to defend it several years later. Because don't forget, lots of these I-140s are pending for a long time unless your EB-1 is pending for a very long time. If you're from India and China, especially from India, even EB-1s are pending right now, EB-2s are pending, and EB-3 is going to be waiting for a long, long time. So chances are that I-140 is going to be defended many years from now at the interview, if they continue to do interviews. So document accordingly.
I think also file now if you're considering it as soon as possible, because it seems like the climate is changing
very rapidly.
Right, for the worse against having skilled labor from overseas.
So this is our update for 2018. In our next video, we'll talk about naturalization and family issues for U.S. immigration. Please stay tuned. Thank you very much.